Our next speaker is Joanne Davies. And as I indicated when I was doing a brief overview of Bill 20, Joanne will be giving you the nuts and bolts of Bill 20. Joanne was in private practice but has been counsel for a number of years with the Ministry of the Attorney General in the Municipal Affairs and Housing Department or Ministry. She practices in the planning and municipal area, has been very much involved in the provisions of Bill 163 and Bill 20. Joanne received her BA from the University of Toronto and her LLB from the Osgoode Law School. She is a past chair of the Canadian Bar Association Municipal Section. Without further ado, I would ask Joanne to come forward.
Thank you very much for asking me to come today and speak. I was asked to talk about Bill 20 and specifically amendments to the Planning Act, and that was a bit of a relief because I've been spending a lot of time on the Development Charges Act recently, and I think in the nature of a public service announcement, I'm just going to take a moment to talk about Bill 20 Development Charges Act because I've received a lot of phone calls from lawyers both acting for municipalities and private developers about the parts of that bill that deal with the minister's approval of new bylaws. And I would simply commend to you to read very carefully the Bill 20 development charge provisions integrated with the existing provisions in the Act. Because what I think you will find is that unless a development charge bylaw or an amendment thereto is for the sole purpose of deleting the term or reducing the charge, it needs approval of the minister. And a lot of people have been flipping that on their head and saying, well, if it doesn't increase the charge, I don't need approval. And I think you should read the provisions very carefully on that point, because we certainly don't want bylaws to be void or voidable. The other part of that is you should be very careful about the procedures, the existing notice and public meeting procedures, because there's nothing, I would suggest, in the bill that says even if your bylaw or amendment doesn't need the approval of the minister, that you're relieved from those procedural requirements. And I think you'll find that even if you're amending your bylaw solely to delete the term, there's nothing that says you don't have to give notice and have a public meeting. So I am just making this point so that you may look at that if you find yourselves in that position and give your advice accordingly. But I looked at the title of today's program, and it was Common Sense and Sensibility, and my topic is procedural amendments, getting to decision. And I thought that some of you might take that to mean that it's only common sense that you obtain a planning approval. Well, I will leave that to time and history to tell, but I'm going to focus on the process of getting to a decision with a planning application. And I would suggest that there's probably 4 or 5 stages to the planning process. The first is an idea or concept for land use or land division. The second is making an application to achieve that use. The third is the review and analysis of the application. The fourth is the decision. And then fifth, if you're unlucky, is appeals. Now, the first part, the idea or concept, I'm going to leave that to my colleague Steve Diamond to talk about whether the type of proposal that's possible in the new planning system differs from the previous system. And I'm also not going to deal with the part of the planning process that takes place before the Ontario Municipal Board. Susan Plamondon and Alan Cohen are going to address that part. What I'm going to focus on are 3 components of the planning system that have been affected by Bill 20, being the application, the review, and the decision. First, the application. Now, I think that the first step is to figure out who the approval authority is, because that is something that the bill changes. It's something that will continue to change, and I'll suggest it at a fairly significant pace. And it's also important to understand not only who the approval authority is, but how they got their authority. And that is because the Act now distinguishes between delegation and assignment, and there are subsequent things, subsequent rights and powers that flow from whether or not you were assigned or delegated approval authority. Now, first, delegation. There's a new subsection, 4 sub 2.2, that enables the minister to delegate his approval functions to planning boards on his or her own initiative. So that means whether or not a planning board asks for a particular approval power, it may very well end up with that approval power. And that's similar to the existing provision that came in through Bill 163, where the minister can delegate to councils without their consent. So the first step is to confirm whether or not a body's been delegated, and then the subsequent step, I would suggest, is to look at the conditions attached to the delegation, because those conditions may give you some clues about the process that that approval authority must follow, perhaps even above and beyond the process set out in the Planning Act. Now, with respect to official plans, the Act clearly has both assignment of official plan approval power and delegation of official plan approval power. Subsections 17, 4, and 5 provide that counties with official plans that come into effect after the proclamation of Bill 20, after May 22nd, 1996, are assigned the authority to approve local official plans and official plan amendments. And the idea here is that once a county has an official plan that incorporates the range of policies that is thought to be necessary, and that plan is approved by the minister, that county then effectively becomes responsible for planning of the municipalities within the county, including both the approval of that local municipality's official plan and an official plan amendment. That section, 17.1 sub 1, is also amended to include the concept of county council, which in effect means that the county can delegate this approval power to approve official plans and amendments at the local level to a committee of council or to staff. And I think this means that there's a great deal of flexibility regarding how planning will be done at the county level, and it will be very interesting to see whether counties that aren't currently planning and don't have a planning program, whether they move into that arena. And it will also be interesting, I think, to look at the effect that MPAs, municipal planning authorities, may have on this, because I saw some releases this week, or last week perhaps, where municipal planning authorities, too, have been created, been approved by the minister. With respect to subdivisions, Bill 20, subsection 51.8, assigns subdivision approval functions to the counties of Hastings, Prince Edward, Victoria, Peterborough, Lambton, Bruce Grey, Wellington, and Huron. Of those 9, three of those counties had been previously delegated, but they're now all assigned. And all other counties will be assigned subdivision approval authority when they have an approved official plan. And so the issue of incentive to planning, I think, is also relevant, and even perhaps more so with the subdivision powers. Now, the reason I suggested that you should be careful or cautious in looking at whether that county, that approval authority, is assigned or delegated is because with powers of sale, councils that have been assigned consent granting authority may approve applications for power of sale, but not councils that have been delegated that authority. And so those councils which were delegated consent granting authority must request the minister for a delegation under power of sale, and the normal process applies. So this reinforces the point that you must know who your approval authority is and how they got their authority. Similarly, with part lot control, subsections 57, 7.1, and 7.2 are changed in order to assign the authority to approve bylaws exempting lands from part lot control to approval authorities that have been assigned subdivision approval power. Now, we now know, hopefully, who the approval authority is. The second component of the application process, and I think Virginia touched on this, are the prescribed information and timeframes. Now, Bill 163, for the first time, established a process or a concept known as prescribed information, and it said that in order to have a planning application, these are the things that must be contained in the application or attached. And it also set for the first time timeframes in which a municipality or an approval authority must make a decision. Bill 163 also changed the timeframes for zoning and subdivision because it said 30 days isn't realistic for a municipality to deal with an application. If we're to have meaningful planning and review done at the local level, the timeframes need to be longer. Now, Bill 20 comes along a short time later, and it tinkers with the prescribed information, and it changes the time frames. And I'm not going to dwell on these because I think they're self-evident in the bill and in my materials, but there's a couple of points I would just like to emphasize. With zoning bylaws, the clarification on prescribed information is that it is the prescribed information only that starts the clock running. And there were a lot of issues about the situation where municipalities required additional information, often referred to as required information, and they took the position until they got the whole package, the time frames don't start to run. The requirement for them to hold a public meeting, make a decision, and of course the developer's ability to move something onto the board. And so those time frames run with only the prescribed information. The additional information may be asked for, may be required, but it doesn't stop the time frames from running. With respect to plans of subdivision, similar changes are made. Again, there is prescribed information. It's contained in the regulation referred to as the notice regulation that's in your materials, and it is that information that triggers the time frames. Similarly, the time frame is changed, and the time for making a decision on an application for draft plan of subdivision is reduced from 180 days to 90 days. So what you're seeing is some attempt that different types of applications have similar time frames, and that you would be encouraged, of course, to make those applications at the same time. I won't dwell on consents. Similar changes are contained in those sections. On official plans, probably the most notable change is that the 14-day waiting period between the time when council held a public meeting and they could adopt a plan or amendment is removed, the cooling off period, so you can hold your public meeting and adopt in the same evening. And also, the failure to give notice of a public meeting within 45 days triggers the right of appeal. And again, there's prescribed information for an application to amend official plan. And for example, that's found on I-69 of your materials, and it has 19 specific items. So it's still a change from the days when, as long as you knew who was making the application, what the land was, and some vague idea about what they wanted to do with it, constituted an application. There's a lot more detail required now. So generally, those are the significant changes to the application part of the process. The next part of the process I'd like to mention is the review process. You've got your application in, and what happens with it. I think there's two major areas I'd like to touch on. And the first is what I call streamlining changes, and specifically the provincial perspective on those. And then secondly, the planning instrument changes or the municipal perspective on those. Now, some of you may have had the benefit of hearing about an initiative called Municipal Plan Review. And you're not going to find it in the Act, but it is a fundamental change to the review process and is affecting many municipalities across the province. And I know some of you here I've met with on this initiative. With the cutbacks in the provincial civil service, and particularly in ministries like natural resources and environment and energy, planning, as it's traditionally been done in those ministries, the resources aren't there, or they are rapidly being depleted. And as a result, those ministries have chosen to focus their resources on other parts of their program. So the old days, when a municipality got approval authority, didn't have any expertise, circulated the application to ministries, got the technical circulation comments, and made a decision, are rapidly behind us. The provincial facilitator, Dale Martin, decided that that could create a lot of chaos out there and began an initiative known as Municipal Plan Review, where with a team of representatives from all the ministries, it is going out to meet with municipalities to put in place a framework where they do their own review and applications are not circulated, site-specific applications, consents, variances, zoning bylaws, site-specific OPAs, any non-policy type of document is not circulated to provincial ministries. And what that means is, in municipalities where they have extensive expertise and where effectively there's just been a lot of duplication, nothing really changes. We just eliminate the duplication. But in more cases than not, in municipalities where the expertise doesn't exist, there have to be creative new ways of doing review. And that is the concept that you may have heard about called alternative review mechanisms. And it involves finding ways for that review or circulation, which has traditionally been done by ministries, to be placed somewhere else in the process. For example, in, I believe it's Halton, they're using a peer review where the developer pays for a second consultant to review the report. So there's issues there about costs, but the costs have been put on the private sector, and that's a tool that they're looking at. In Durham, they're using a different system, which is where a technical report or study is required. The developer pays for it, as always, and the study is done, as always, but the municipality directs the study. So the theory being no review is necessary because it's been done to the satisfaction and on the terms set by the municipality. In others, conservation authorities are stepping in, and they've prepared a generic business case which they're using to present to municipalities, where effectively on a fee-for-service basis they're performing a review which has traditionally been done by ministries. And the list goes on. So the way your application is dealt with, is reviewed in the new system, is going to be very different. So it's something that you would want to find out about from the particular municipality that you're dealing with. The next change, and this is a change contained in the bill, is the amendment to the definition of public body. And what this means is that a public body, for the purposes of appealing a decision, and I'm sure you know, no longer do we have this concept of referrals. Referrals are totally eliminated under Bill 20. It is a totally appeal-driven system. Provincial ministries may only appeal through or by the Ministry of Municipal Affairs and Housing. And this has been referred to as the one-window approach, so that planning, because of a lack of provincial resources and because of a desire to coordinate at an earlier stage provincial review, is done through the Ministry of Municipal Affairs and Housing. And the teeth behind that is the fact that no other ministries have a power of appeal. Now, flowing from one-window appeals, as it's referred to in the bill, is the concept of one-window planning. And you won't find that in the bill, but it is the way that your applications, applications by municipalities for approval of official plans, applications by private developers for official plan amendments that have been adopted, say to a regional plan or a major secondary plan containing policy, would be dealt with by the province. And that will be that there will be one position or comment back to the municipality. It will only come from municipal affairs, and it will incorporate all aspects of provincial interest. So you won't go to the OMB file and flip through and see if Ag and Food sent a comment or if Environment sent a comment. It's going to look different. And that is another change that is an administrative change that goes with Bill 20. The second component of the procedures part of the planning system are some changes in the review process on specific types of applications. And I'm just going to note a couple of the most important ones. It's interesting to note that with official plans, when municipalities are considering their update to their plan through their 5-year review, they now must consider written submissions in addition to oral submissions at a public meeting. With zoning bylaws, there is now a requirement that the public be informed in the actual notice of the public meeting that if they fail to make submissions to the local council on the bylaw, the OMB has the power to dispense any subsequent appeal. And of course, the parallel change is the board now has the power to dismiss an appeal to a zoning bylaw for failure to participate in the process at the local level. So now that's consistent with the official plan process. So it is attempting, I think, to force people to disclose early and to participate at the local level. And how the board might deal with that, I think, will be covered by Steve Diamond, so I will just leave it at that. I think another important change on the zoning scene is the fact that municipalities must give notice 15 days after the bylaws passed and forward any appeals to the OMB 15 days after the last day for filing an appeal. And I think that that's an important change in terms of moving the system along. And interestingly enough, and one that may have escaped your notice, the same provisions appeal to interim control bylaws. So now, a municipality who's choosing to study an area has to be expeditious with the process. And if there's an appeal, it goes off to the municipal board within 15 days. And similarly, for notice of passage of the bylaw. On subdivisions, you will see that the notice requirements have been reduced in the sense of the scope, and that notice will only be given to the applicant, the affected municipalities, and those who specifically requested notice. So all those people who made submissions won't automatically get notice. Also, the requirement to recite the appeal rights on the notice is gone. So municipalities may choose to do that, but it's not contained in the regulation. And the appeal period against the decision has been reduced with subdivisions from 30 days to 20 days to match the zoning bylaw, because of course there were concerns that you might be out of time on the bylaw, but you could get that subdivision. So now they match. One other interesting little change is that on subdivisions, there's an amendment that where the appellant is required to provide the OMB with additional information within the time specified by the board. The old provision said, and that time shall not be less than 30 days. Now that's been deleted, so the board can set its own time frame. I'm going to skip consents except for one minor comment, which is that if there is an amendment to the original application, the requirement for notice has become discretionary, and the test is whether the board considers it to be minor. Similarly, another minor change is on condominiums. which is that plans of condominium are exempt from the requirements of giving notice of application and the notice for a public meeting. It's determined that that's really a tenure issue in terms of effect and didn't need the normal notice and public meeting procedures. The third and last component of the changes to the planning process in a very overview way is the actual decision. And in my own view, the absolute most interesting part of this are those little provisions dealing with exemption. Because if those provisions are used, it will mean that official plans and official plan amendments do not need the approval of anyone, and they will be like a zoning bylaw. So once the municipality makes the decision, you have a standard 20-day appeal period, and then that official plan or that official plan amendment is in effect. And it will mean that for people watching and concerned about principle of development issues, the process for public involvement will be much, much scoped. And certainly the minister has said that he intends to move very quickly in implementing the exemptions, and I believe you will see some consultation, possibly a paper soon, talking a little bit about the framework and the process. But that could radically change the way the decision is made on official plans. I've included in there some information on transition provisions and the notice regulations, and I'll just leave those to your reading. But in conclusion, I think that the process changes in Bill 20 build on a theme initiated under Bill 163, and that's that site-specific planning is done at the municipal level, and you see that through changes in approval authority, through changes in the process, and it focuses the role of the province back on policy development. And it also attempts to make some changes to the system to make it more efficient and more streamlined. And I guess on that front, the proof will be in the pudding, and we'll see whether the Planning Act is here to stay for a while or we see some more changes in the future.
Thanks, Joe. Our next speakers are Alan Cohen and Susan Plamondon, dealing with early dismissal OMBs. And you want to sit here, Susan? Then I'll move along. On the OMB's enhanced role. Susan is a graduate of the University of Toronto and of Osgoode Hall Law School. She was called to the bar in 1976 and initially joined the firm of Stiver, Vale, Pepiot, and Arrington. She then worked as a sole practitioner beginning in 1983, and then in 1986 was invited by the town of Newmarket to form become its first in-house legal department, and I know that well. I did the same thing in Pickering many centuries ago, but anyway, and an interesting undertaking that is. Susan is right. Member of the Canadian Bar Association and the York Region Law Association. She's a member of the Board of Directors of Crime Stoppers of York Region, chairman of the County Day School Foundation, and former chair of the Board of Directors of the County Day School. She also served for many years on the Board of Directors of the Children's Aid Society of York Region. Alan Cohen is a partner with Solway Wright in Ottawa. He articled with the city from 74 to 75 and was called to the bar in 1976 and was with the city for a period of time. He then joined Solway Wright in 1978, and as I say, is a partner in the firm, and his practice is restricted to municipal planning, development, and environmental law matters. He was a member of the past Merrill City of Ottawa Task Force investigating housing and councillor salaries, and he is currently the president of the Great Canadian Theatre Company. And I'm happy to see that, as with Susan and her extra professional activities, both of them have a life outside of the wonderful practice of law. So I'm not sure which is going first, but I will turn it over to you. Alan, thanks.
I think I'll go ahead. Thank you. It's a pleasure to be here this morning. I took the topic that was assigned to me as an opportunity for conjecture. And I hope you'll read my paper. I attempted to make it light. Forgive me if I was on the one hand glib and on the other hand reflective, but I thought the topic called for it. Also, I would point out, coming from Ottawa, it's a wonderful opportunity for me to present some views from long and always forgotten Eastern Ontario. When you guys, I said to somebody outside, have an issue in Toronto, it becomes law in Ottawa whether we need it or not. I decided the best way to tackle this is to take a look at past planning acts to see indeed whether the board's role for dismissal has been enhanced. And here's what my secretary did. She gave me my report. If you can read this from where you're sitting, then you're too young to give this lecture. Before the 1983 Act, when I started my practice in 1976, the board had powers of dismissal, and I can tell you that they were rarely used, and I don't know of any case in my neck of the woods in Ottawa-Carleton between 76 and 83 when the board had the audacity to dismiss an appeal or a referral request without conducting the full hearing. And I think if we reflect upon the act of the time, but more importantly, the time itself, it may give hints as to why the board behaved the way it did then and why it may behave the way it's going to behave in the future. The first is this, and I guess most important, is the issue of onus. That's a word we were not allowed to use before the OMB until 1983, although some cases snuck it in. And as practitioners, we all knew it existed. And the onus was fairly simply this. And I worked for a city, as Bob mentioned, at the beginning of my career. Whether you were adopting an OP, an OPA, or not even a zoning bylaw, a restricted area bylaw or amendment, the onus fell squarely on you when you came before the board to present your case. And it therefore is, I think, consistent with that notion that the board would have been reluctant to dismiss without a hearing when they expected you, the municipality, to come forward with the case. One of the other differences between that age and this age, and it was marvelous for me to listen to the development charge debate, is that we viewed ourselves as extremely wealthy in the 70s. And we view ourselves as very poor today. This is how wealthy we were in the 70s. In Ottawa, at any rate, and I suspect you had similar things in other parts of the province. In our planning department at the City of Ottawa, we had animators whose noble job it was to go into the community and rabble-rouse with respect to planning decisions that the very council itself was making. And I can remember as a mere junior having one of the animators come into my office and demand to read my file so that she would be in a better position to both encourage and deal with an objection to the bylaw that her animated group was going to file in an area where the city was trying desperately to get long-forgotten lands developed. Well, can you imagine taking that objection and then my writing to the board and saying, hi, would you mind dismissing this without the necessity of a hearing? I would have lost my job. I think the other difference, well, let me jump to today. Today we perceive ourselves as poor. At least in different parts of the region. It was fun to hear the development charge discussion and how much municipalities here are ignoring financial constraints. Ottawa repealed its development charge bylaw. All the other municipalities are reducing their development charges. We're caught up in poverty in Ottawa. And perhaps it's because civil servants who enjoyed a kind of protection over the years have lost that. And so that may be an inkling as to what the board is going to do. In times of poverty, you can't afford delay. And so it may well be that some of these things will be well received by the board. The other thing is that the board perceived itself as being in the business of conducting hearings. If you talk to the board, and we all do in our practices, and in my part of the world we call Helen Campbell, the board staff member for us, And they were in the business of conducting hearings. And I'm not sure whether that's going to be true in the very near future. The other complete difference, and I think it's represented in changes over time in the Act, is this, and this was drummed into my head as a student, as an articling student, and as a junior, is that the municipality was a mere creature of the province. It had no inherent power except that power which was given to it. And we were made to recite that like the catechism. And what we see today is an emerging power in municipalities, and although its constitutional status, I suppose, hasn't changed, what has changed is that more and more power is being delegated to the regional level of government and to the local level of government. And so at that time, before the 1983 Act, you'd have to be awfully audacious again to suggest that the objection would be dismissed when in fact it was just a petty creature, a petty legislature that had adopted the legislation, and its decision had to be reviewed. Now there is more status, and one hopes, perhaps hopes against hope, that the board will be more respectful of it. In 1983, we had what I still perceive to have been the most monumental changes to the Planning Act. And it wasn't just that we finally got to call zoning bylaws and not restricted area bylaws. But for the first time ever, we talked about appeals. And zoning bylaws were appealed. And so there was an expectation among us practitioners that this would cause significant changes at the board. The first such change, I think, was realized, and that is that on the case of a zoning bylaw appeal without an accompanying official plan amendment referral request, the appellant went first, except in very rare cases. Or, as is still the case today, the municipality might put in an overview of planning without cross-examination being permitted, so that the appeal status changed, as I perceive it, the procedure of the board and the board's, therefore, perspective on what municipalities were doing. Notwithstanding this change, however, and notwithstanding continued powers of the board to dismiss without the necessity for a full hearing, again, I can tell you that in my neck of the woods between 83 and 94, Bill 163, there were very few, if any, dismissal cases, notwithstanding the fact that, in my view, some were deserving of it. Now, this is the one aside that I will indulge myself here. The greatest thing about the 1983 Act is this. The previous Planning Act was repealed, and if you wanted to find out what the 1983 Act said, you went to the Statutes of Ontario 1993, Chapter 1, and you could read it from beginning to end. Now, I take it that our government is going to continue to amend the Planning Act, so I'm going to preach some heresy. I beg of you working for the ministry, and I beg of the government that it do something heretical, and that is repeal all former acts. I don't care how confusing it may be at first blush. Give me one Planning Act to pick up and read. The cut and paste version doesn't work very effectively. I don't have the talent to put it all into my computer. In fact, my computer probably doesn't have the memory to take it all. But that was the great asset of the 83 Act. So the 94 Act came along, Bill 163, and it was an attempt to do various things, but in effect expanded somewhat the board's power to dismiss. But those enhancements are really technical. I mean, did you write this? Did you say that? And so most of us did, for goodness sake. I mean, one of the big differences, I guess I should go back to 83, is that in 83 you got a maturation of the pleading process. It's pretty hard to dismiss a lot of cases for want of detail because as practitioners we've all become so clever at writing appeals and referral requests we hardly even count on planners to do it. We know all the terms, we know all the complaints, we know all the magic and all the buzzwords, and on first blush reading they're all pretty good. So that, quite frankly, the bill I was asked to speak to this, so I will. Bill 163 introduced the notion of prematurity as a ground upon which you might have dismissal, and Bill 20 takes it away. is there a change? If you take a look at case law, you'll see that boards have relied upon the issue of prematurity to dismiss in any event, and so I'm not sure how great the change is in the law. So, here are the real comments I wanted to make today, and they're not so much about the Act anyway, but about practice and the board. And they are this. One, the board is under the wrong ministry. Imagine the following scenario, and I think I have this in my paper. There's only one referral request or now appeal to an OP. There's only one appeal to a zoning bylaw. And wouldn't you know it, they're both from the Ministry of Municipal Affairs, and you write to the board, which is under the aegis of the Ministry of Municipal Affairs, and say, would you mind dismissing this for want of sufficiency? And guess what the answer is going to be? It's preposterous. So that the board should be independent for other reasons, and this is one of the reasons, again, that it should be independent. Two, the board has the right to dismiss on its own motion, and I genuinely hope that it does not do so. I think it would be wrong, except in the most extreme cases, for it to do so, where it's clearly a procedural defect and the would-be appellant simply refuses to perfect. Other than that, I think it's inappropriate, and I hope the board does not do that. Next, the board is consumed by how poor it is, just as we are all apparently consumed by how poor we are. So it's going to reduce its numbers, and it's apparently in the process of reducing its staff members. This at a time when it's finally introduced things like case management and mediation, and in my part of the world, I don't know about your part of the world, we've gone from waiting 14 to 18 months for a hearing to 4 to 6 months. We're just cranking those cases out, and it's a marvelous thing. And my big fear, quite frankly, and of course the board is not here, but one hopes these things get back, is that, as T.S. Eliot said, is the greatest of all sins, that the board will not do the right deed for the wrong reason. That it must not start dismissing because it feels it has inadequate numbers of members or inadequate staff members, and will in effect deal with it. I don't know how you're going to deal with things here. I understand that your part of the world is going to market value assessments soon. And that's something we went through in Ottawa Carleton in 1981, and we had as many as 25,000 appeals before the ARB at any time, all working their way, not all, but many working their way through the OMB. It used to be that those things went to county, now then district, now disappear to court. Now they go straight to the OMB. I don't know how you're going to deal with that kind of caseload with fewer staff members and fewer board members, but that's going to give you, a lot of you, cause for concern, and a lot of you are going to have to try to get dismissals in certain kinds of cases. So here's the final comment I wish to make, and it is this, that in my view, I will be so bold as to say, the reason that the board has not dismissed, as it has been able to statutorily, historically, is that it is far too concerned with its own optics. It is not just in the business of conducting hearings, but in my view, has always been overly concerned about how it appeared. And I genuinely hope that that is something that will change with somehow the changes to the Planning Act. Perhaps it will be an amalgamation of all these different reasons. Put simply, my thesis was going to be that the Act has changed and there will be more instant dismissals by the board. I reviewed the legislation. I really don't know what the board's going to do. Here's what the board should do, and it's what the board always should have done, and that is where an appeal, forget the wording of the Act, as I say in my paper, whether it's frivolous or vexatious, or for purposes of delay, all those, in my way of thinking, are mostly silly. The real point is this, where an appeal is filed that doesn't really address the benefit that's being gained by the legislation that has been adopted by a group of elected officials, where the appeal simply does not demonstrate true prejudice to the appellant or true prejudice to his community. then it should be dismissed. That should be the simple ground. That should have always been the ground. I suspect that always was the ground. It was never exploited, and I can't wait for the day that it is. Thank you very much.
Susan.
Well, since Alan was philosophic, I had the opportunity to read his paper before I wrote mine. I went the technical route, just to let you know, because I, like everyone else, have the same problems trying to read Bill 163 and Bill 20 and put them all together and get a consolidated version. So in the very, very narrow area of appeals to the municipal board and what the board's power is, at the back of my paper, you'll find what I hope to be an accurate summary of after Bill 163 and a consolidation of the relevant sections in the official plan, zoning, minor variance, and consent area, so that maybe in that one small area, until the law book publishers get out there and give us a consolidated version, which will become my Bible, I hope that's of some assistance to you. I have to say, in the old vernacular, to try and get through a hearing quickly, I'd like to adopt the comments of my friend sitting to the right with respect to the board and what it can and should be doing and what its resources are. I heard last week that there were 26 layoff notices given within the board to various, what I would call the people I dealt with on a day-to-day basis, on a very regular basis. And one has to wonder, and I'm perhaps getting to the end of my comments before I start them, but one has to really wonder, when Alan's made the comment, what is the business of the board? It used to be in the business of conducting hearings. Is it going to now be in the business of getting rid of hearings instead of having to have them, where, arguably there may be some valid and good reason? I'm particularly concerned about the small things like the minor variance and consent appeals, where 9 times out of 10, I speak as a municipal solicitor and I don't often attend those hearings, but often it's an unrepresented individual. And that unrepresented individual doesn't know how to go about writing a letter of appeal, and is an aggressive developer, an aggressive municipality going to try and knock them out of the blocks right at the beginning because they haven't properly articulated their planning reasons? And will the board continue to do what it has done, at least in my experience historically, and that is bend over backwards to make sure that the unrepresented individual really feels they've had their say at the appropriate time? My suspicion is that maybe they'll be asked to be given the opportunity to have their say in the context of a motion to dismiss instead of in the context of a full hearing. But it's my hope that the board will continue to be sympathetic to the individual who may not be represented, particularly in the case of minor variance and consent situations, because it may seem relatively small and trivial to those of us dealing with the much bigger issues, but for those individuals, that is their home, or it is their plan for their future, and it shouldn't be trivialized. Now, really the substantive changes, to get back to the bare bones and the basics, happened with Bill 163 in the context of the appeals. And Bill 20 just did a little fine-tuning, and I think that becomes apparent when you look at that little consolidation I put at the back. The only big difference is that Section 17, dealing with official plans, was completely reenacted, and it is one of the few places in Bill 20 where, at least in the area of official plans, you can get the whole picture in one spot. And the grounds have been enhanced. There's no doubt about it. And they are, what surprises me is, to some degree, administrative kinds of issues. Haven't paid the fee, your reasons aren't in writing, or if you've given reasons in writing, they don't disclose a planning ground, a land use planning ground. Now, I don't really know at the end of the day, to echo my friend to my right, whether or not that's really any different than what was in fact argued at hearings before. Motions to dismiss, however, didn't tend to focus on that too much. We all got into the frivolous and vexatious arguments, even though technically they weren't available to us, I think, except in the area of official plans. That was the minister's power to refuse to refer. And as we heard earlier today, everything is now an appeal. Everything is framed in the context of an appeal. And basically what you'll find is the basic reasons that you make your motion for early dismissal is there weren't any oral or written submissions prior to adoption of the plan or the amendment, or they fail to explain what they are. And that one is of concern, I think, with respect to, again, the unrepresented ratepayer. You might find it surprising that I'm worried about the unrepresented ratepayer, since my job is to represent the interests of the local council, but we all know political decisions get made that may not necessarily be the right decisions in the context of communities. And so, and it's been my experience, not necessarily in my municipality, because we haven't had too many OMB appeals, but it's been my experience, it's been an abdication in some cases of responsibility to the board, where a municipal council doesn't want to make the tough decision, looks at who can best handle the appeal, and either does or doesn't do something based on not necessarily what's right for their community, but because there's a good political reason not to. And in the case of early dismissal, I think you might see municipalities looking for ways in the context of early dismissal to do the same thing and to get it over with much more quickly. And that's something I think we're going to have to wait and see about. I simply don't know how it's going to work out, but I suspect you may see municipal councils actually getting involved in situations where it has refused to act because it doesn't like. It has failed to enact, or it has refused to act. It's refused to act because it doesn't have all of the information that it wants. Maybe the prescribed information's been provided, but it doesn't have all of the information that it wants, and it may want to get to the board early on an early dismissal motion. I don't think you'll see them do it when it comes to the individual ratepayer appeal, but I do think you might see it when it's the large landowner developer and or the old chestnut that happens in developing communities like mine is, where you've got a commercial objection because they're worried about competition and not really worried about land use planning, and it is for delay. You know, that doesn't really happen, but I think that some of us could all point to a case in our own municipalities where that probably has. The board's fee hasn't been paid. That surprises me. I think that, I don't know that it needed to be enshrined in legislation, frankly, but unless the board is planning, because it's suffering the same resource problems as everyone else is, that the fee to appeal is going to become, $5,000, I just can't see that whether or not you've paid $250 or $150, as the case may be, should have you knocked off the blocks right off the top. The grounds for appeal are not conjunctive, they're disjunctive. So arguably, any single one of those grounds would be sufficient for the board to dismiss early. And I can hardly wait till that development community gets out there and sits and tells the board that it wants to knock out a ratepayer appeal or a ratepayer association appeal, well, because they didn't make representations at the public meeting when they had the chance to do so. I've already had calls from people saying, that appellant, were they at the public meeting? Did they make a submission? I'm anxious to get them knocked off the block if that's the case. And I really wonder, how much good is really going to come from all of that. I just don't know. Something that Alan mentioned, and I'm not sure I agree with him on, and I'm digressing or moving ahead a little bit, is this issue as to the removal of the grounds for early dismissal on the basis that services aren't available, usually official plan and zoning bylaw amendments. As we all know, if we look at the cases and we look back, at the Planning Act as it was before Bill 163, if you were the municipality, you relied on that provision if you really felt that you couldn't accommodate the development, if you didn't have the services. And sometimes, frankly, you might have wanted the development, but it gave you the ability to say, I can't approve you, I don't have the services. And the next thing you know, the developer would be front-ending all of those costs, and never mind development charges. There was a financial incentive to do it, and they absorbed it, and they didn't really care. Those are the heady old days of the late 70s and early 80s. They really didn't care. But I'm wondering, and I don't have the answer, but I'm wondering if by the removal of that as a ground for early dismissal, someone might not successfully argue at the board that since it wasn't important enough, it was in the legislation and it's been removed, even though it was only in there for about a year, whether or not the board effectively is going to lose its ability not to approve official plan amendments and zoning bylaws because of prematurity, lack of services available. Have we lost something by putting something in and then taking it out that was intrinsically understood all along? I don't know what the answer to that question is, but I suspect somebody will make that argument at some point. If it's not important enough to deal with on the basis of early dismissal, is it really important enough when you get right down to it, to the merits of a land use? We all know we can stick provisions in official plan amendments that say, here it is, we've done it, but we held back by not doing zoning amendments to implement the OP. Maybe what we'll end up with is official plans being approved and land use planning occurring well in advance of it actually ever getting into the ground, on the basis that we'll just stick a clause in the official plan, or the board will direct a clause in the official plan amendment that says, however, until the services are available, you can't do anything. And most of us know that once the land use issue, a change in land use, I shouldn't just say in general terms, but the change in land use has been decided, how easy it is to change it again, to change its form. And my concern is that will the board have lost its ability, because it was in and now it's out, to say that land use is premature because services, the hard services, aren't available. We can argue for a long time about soft services and hard services. I share Alan's concerns too about the board's own initiative. That to me is one of the biggest changes in the grounds for early dismissal. I mean, the municipality could always bring the application, and the landowner could always bring the application, and the appellant, of course, wasn't interested in bringing the application. The appellant was interested in getting to the hearing. But it's the board's own initiative now that has me a little bit troubled, because I do wonder whether or not, again, to use Alan's words, the board is going to be out of the business of conducting hearings on the merits and will be in the business of conducting hearings on motions, particularly of their own initiative. I can't imagine them wanting to do it for anything other than a purely administrative issue. But even then, I find it difficult. Surely an interested proponent, given the new grounds, would save the board the trouble of bringing its own motion if the appellant hasn't bothered to appear at a public meeting, or if the fee hasn't been paid. I just can't see where the board really needs that authority, and I haven't asked the drafters of the legislation what they had in mind, but I don't know why it's necessary. And one has to really wonder, if the board brings the motion on their own initiative, what are the chances it's going to fail? I mean, if they don't really think that they want to throw the hearing out, why would they bother? And how can they really be said to be objective or perceived to be objective in that context? That actually, I mean, that really blows me away. I just can't see a tribunal that acts in a quasi-judicial capacity doing that to someone. I'm not aware in the rules of very many cases where the courts, the judges, can bring something on their own motion in a file. That's up to the people who have the interest in the matter. And a municipality and a landowner or an appellant will be worried about those things, and I don't think the board needs to be. And I think it diminishes, in my view, the credibility of the board to put it in that position. At the end of my paper, looking at the time, at the end of my paper, I've asked a few questions, like what's really new, and I think I've discussed that with you. How will they be used? I think you will find, I think I've given you some examples of that. I don't know on what basis and what the standards will be, and we'll have to wait for some decisions as to whether the board will really dismiss if only one of the criteria are met. I'd like to think they would never dismiss unless there really was no planning ground, no legitimate planning ground disclosed by the appeal. And what's a reasonable period of time to explain your position if you haven't done it properly? I guess we'll wait to see. We heard earlier that the 30 days is gone. You know, what will become reasonable? And I think I've mentioned some of the concerns that I have, and the primary one being really the board's own initiative. I'm really not sure how that's going to work. And I guess we'll just have to wait and see. Thanks.
I'd like to introduce our next speaker, Steve Diamond. Steve is a partner at McCarthy Tetro in the Municipal Environmental Group, formerly of Diamond Fairburn. Steve, why don't you come on up while I'm paying you accolades. And the greatest accolade I can pay, Steve, and we often are it seems on opposite sides of cases, and I'm always pleased that that's the case, and not because of any suggestion that Steve is in any way a pushover, but he's one of those people who, forthright with respect to his client's position, willing to discuss what the reasoning is behind it, and an ability to try to rationalize where are we going from here. So he's a very worthy opponent, and I'm always pleased to deal with Steve. I'd like to, just by way of advertisement, say that Steve had raised with the faculty some issues with respect to his proposals and views that he had discussed with a number of practitioners concerning amendments to the board and to certain policy and practice matters before the board. The faculty has discussed those. You've heard the results of some of that discussion from Susan and Alan in particular. And the faculty, I would be fair to say, with the government members of it taking no position, but the other members of it strongly in support of the positions that were put forward by Sue, by Alan, and which will be elaborated upon by Steve. We think that there are issues there that need to be addressed. We do believe that we have a government at the moment who is responsive to well-reasoned concerns being brought forward. They are listened to. We hope there is an opportunity to make some modifications on the basis of those well-reasoned concerns. And we hope that if you agree with us on some of the modifications and amendments that are coming out of this morning's conference, we exhort you to go forward and do something about it. Talk to people about it. Write people. Tell them that you are concerned. I'll leave Steve to elaborate further.
Thank you very much, Jim, for those kind words. It is true, as you said this morning, we are a close-knit bar, and having said those nice words about me, when I look around the room, at particularly the number of municipal lawyers that are here, I wonder why you always give me such a hard time. But having said that, having given the topic changes to planning practice and procedure, did give me the opportunity and the forum to talk about some of the things that are concerning to me, particularly in light of the new act and in light of what I believe to be the expanded powers of the Ontario Municipal Board. And when many people heard that Bill 20 returned the Planning Act to the words "have regard to provincial policy," immediately assumed that we were back to the old planning regime. And in my view, that is not the case. It is clear that the new Act and its policy statements have incorporated many of the provisions from Bill 163, so that it is not a safe assumption, even when interpreting the words, that the municipal board only has to have regard to these provincial policies, that we are in the pre-Bill 163 regime. And I'll discuss that a little bit further on, and it's mentioned more fully in my paper. And we've also heard a lot in the newspapers and press releases coming from Queen's Park that the intent of the Act is to leave the decision-making at the local municipal level. And if there's no appeal, that may be the case. But generally, if there's an appeal by either ratepayers or an owner or anyone else in this particular system, the ultimate land use decision in this province, in the event of an appeal, still rests with the Ontario Municipal Board. And this new act, in my view, has actually left the board with more power and authority than it has had, I believe, since the Planning Act has been written, at least since World War II. You've heard this morning about the powers of the board to dismiss appeals, an expanded role, and they can even dismiss them now in their own motion. But it's also important to remember, looking back at our history, that up until the 1980s, all decisions of the municipal board could be appealed to the cabinet. So the cabinet was the ultimate decision maker. In the early 80s, the act was amended so that only those matters designated as a matter of provincial interest could go to cabinet. But again, cabinet, if they thought there was an important matter, maintained the ultimate control. In Bill 163, what we had was a system where every decision of the municipal board had to be consistent with provincial policy, and you had 7 policy statements and 600 pages of interpretation guidelines. And in my view, this was clearly a dictatorial regime from Queen's Park. So what are we left with today under this hybrid, this new act? We're left with a planning regime in which there is no longer any appeal from the Ontario Municipal Board to the Cabinet. The ultimate land use decision has been left with the Ontario Municipal Board, and the Ontario Municipal Board only now has to have regard for provincial policy. So the board has been left with more flexibility than it has had and more authority than it has had in the past. Now, I believe that the Ontario Municipal Board is important in the planning system. It acts as a watchdog. It protects citizens, and that all municipal planning decisions can be overturned. So if there's a concern at the local level that a developer has had undue influence over the council, there's always, and everyone knows, that that decision can be reviewed by the municipal board, an independent tribunal, hopefully. It also protects developers, who, we must remember, generally, for example, in a housing case, are representing those that don't have a home. And they have the right to appeal to the municipal board when a council may be under undue pressure from a very powerful ratepayers group and their current electorate. But it is therefore important, in my view, that it does remain as an independent tribunal with the best members possible, and that justice not only be done, as it is said, but seen to be done. And if the government is going to give the Ontario Municipal Board this authority and power, then in my view, a number of reforms are necessary if the board is to perform its function properly. Now, you've got to get the best members, and they have to be well paid, and they have to have security of tenure. You have heard my predecessors talk about one important issue in terms of the administration of the board. The Ministry of Municipal Affairs right now has the jurisdiction over the Ontario Municipal Board, and yet it may also appear before the Ontario Municipal Board as a party, is what we've heard. I agree with what my earlier friends have said. The Ontario Municipal Board should be moved to the Attorney General's office so that it can remain completely independent. You cannot have the body administering the board and appearing before the board at the same time. It's also my view that a committee should be established from the affected stakeholders, municipalities, developers, and citizens groups, to screen applicants for appointments to the municipal board. The government may want certain people to be appointed to the board. That's fine. But if they put everybody in a pool, they can have 50 applicants. At least if they have the respect and endorsement from the stakeholders, then the board, in my view, will function better. Now, having gone through that system, once being appointed, in my view, security of tenure for members of the board is also important. Right now, most of the members are on 3-year terms. And I don't know how anyone can expect to get proper decisions when you know your term for renewal is being renewed at Queen's Park every 3 years. And there's a great concern that the member may have one eye on the case and the other eye on Queen's Park. And therefore, if you're going to get the best members, and you're going to attract the best members, and we're going to get a fair and just system, then security of tenure is something that the members deserve. Again, you heard my friends talk about that the board's concerned about its own perception. I think if they had a little more security, having been given their role, then it's my view that they would be able to function better. And I guess finally, the last point I would make on this is that I believe that the chairman of the Ontario Municipal Board should be made a non-political or partisan appointment. And we have had changes every 3 years again over the last 2 regimes. Generally, political appointments have been made. They may be very, very fine people, but in my view, again, we should be ensuring a long-term chairman and one who is respected by the stakeholders. Now, having vented my spleen and knowing that I have to appear before the Intermunicipal Board in many instances, and I think it is important, I'd like to come back then a little bit now to the Act. And having said that the ultimate land use decision rests with the Board, what will the Board expect the municipalities to consider with respect to these provincial policy statements, and what will the courts expect the Ontario Municipal Board to consider with respect to the provincial policy statements? And as I've said earlier, this new Act is a combination of Bill 163 and its predecessor Act. And it's important to point out that a very important section remains in the Act from its predecessor in Bill 163. And that's in the very purposes of the Act. And it says, the purposes of the Act are, and I'll just read B, to provide for a land use planning system led by provincial policy. So what we still have enshrined in the statute is what was put in with Bill 163, that the entire purpose of this Planning Act is to have a system led by provincial policy. So it is clear that we still have an explicit, comprehensive, integrated provincial policy-led system. And this is a context that was not present prior to Bill 163 when the words "have regard to" were found. Therefore, in my view, while the wording of the "have regard to" rule has been restored into the Act, its context is very different. And in my view, the Municipal Board and municipalities will specifically have to consider the scope and the meaning of the policy statements, knowing that the purpose of the Act is to have this provincially led policy statement. Now, very briefly, I will now try to review with you some of what I believe these policy statements stand for and what the differences are between the Bill 163 policy statements and the new policy statements. And in my paper before you, there is a comprehensive evaluation of the old and the new policy statements that you can look at your leisure. But basically, I would suggest this. First of all, that the dropping of the 600 pages of contradictory and ambiguous implementation, first of all, certainly is a welcome change. Secondly, I would say that the policies have been tightened and shortened, but I don't think they can be shrugged off that easily. And I do believe that there is a basic theme that comes from a review of the policy statements. For example, under Bill 163, if one carefully reviewed the policy statements, in my view, they clearly contained an anti-development bias. Environment and natural heritage were clearly policies which prevailed over development policies. And I had the chance in preparing this paper to look at the old policy statements and the new policy statements. And every time you had a heritage policy or an environment policy, it was always development will be permitted only if. So only if you met certain specified criteria, could you go ahead and develop. It is my opinion that there is a clear-cut direction in the new provincial policy statements to promote responsible development. And what this new provincial policy statement has is a preamble and principles which did not previously exist in the former policy statements. And the very first principle with respect to development in the provinces of Ontario is as follows: managing change and promoting efficient, cost-effective development and land use patterns which stimulate economic growth and protect the environment and public health. So there is no question. The very first thing we find is this is a policy intended to promote development. When one goes to the very first policy, the very heading has now been changed. It reads, efficient, cost-effective development and land use patterns. And what does it say in the very first part of the policy? Subject to the provisions of Policy 112, cost-effective development patterns will be promoted. I believe that that's a very real difference in terms of how the board will look at this mandate from development will only be permitted if. It is now development is to be promoted. And the policies go on, and it is clear, basic theme, in my view, promote development in urban and rural settlement areas and protect the rural areas. And it's short policies, it's tight policies. I think they're clear. I think they're less ambiguous. And I think it does give a clear and understandable direction. As a matter of interest, the housing policies have been changed. And the whole mandate with respect to affordable housing and the 30% of new dwelling units as being defined as affordable has now been deleted completely. The policy statements now say housing as a general goal is now being encouraged to meet demographic and, interestingly enough, market requirements. They're not just concerned with affordable, they're saying all housing is being encouraged. And again, a very subtle change in terms of the differences between the old and the new. And this one I found makes the case of what I believe they're saying. Under Bill 163, with respect to intensification, the words were, small-scale intensification will be permitted in all areas permitting residential use, except where infrastructure is inadequate or there are significant physical constraints. So right off the bat, it's not encouraging small-scale intensification. It was saying it would be permitted. But and I'm actually one who believes that small-scale intensification, particularly in the metropolitan Toronto area, is something that is very, very important. The services are available. And I would have hoped that that policy would have been stronger at the time. But then they take away, so it's permitted, but if there are significant physical constraints, it's not to be permitted. And I had one case where that was argued, and the resident stood up and said, well, there are physical constraints. We're the neighbors in the area, and we're too close to it. And when you looked at the implementation guidelines, they had a definition of physical constraints, and they said, yes, you had to look at the neighborhood and the surrounding area and everything else, and what good was that policy? Now, in my view, the new act makes it clear. What does it say? Encouraging all forms of residential intensification in parts of built-up areas, and this is very interesting, that have sufficient existing or planned infrastructure. Now, the old policy statement said you develop where there's existing infrastructure. And in fact, you could declare things premature where there wasn't infrastructure. This takes two leaps. One, we're going to encourage all forms of intensification, and in fact, we'll encourage that intensification The services may not be there, but as long as there's planned infrastructure for it, then that's enough. We want to encourage that intensification. Because we have to, as the policy says, create a supply of new housing units. So the policy statements have moved from being merely permissive and in some ways with respect to development restrictive to one that is very positive and encourages community development and sees it as a benefit. And I believe that those policy statements will have to have some meaning at the municipal board. The very last one, I don't have time to go through them all, but there's the last one that I'd like to deal with is dealing with the environmental and heritage policies. And again, I would suggest that very significant changes have been made to the former policies. It's interesting, there are still natural heritage policies and hazard policies, but there is no longer a separate environmental protection policy. Furthermore, there used to be an absolute prohibition against development in what were defined as significant ravine and rivers, valleys, and stream corridors, and in lands adjacent to there too. That absolute prohibition has been removed under the policy statements. The policy statements now only prohibit development in significant wetlands and in endangered or threatened species habitat. In all other areas, development is permitted provided you can show no negative impact on the natural features or the ecological function for which the area is identified. Again, a shifting in philosophy. Yes, we're concerned about the environment, and you have to have regard for the environment, but as a matter of a provincially led policy system, from the provincial perspective, it's policies that are aimed, in my view, to try to promote development having consideration to these matters. So the emphasis has changed from you can only develop if to you can develop, but let's make sure you're doing it in a responsible manner. In conclusion, I'll even finish on time. No, we're all getting hungry. Under the new Act, while the Act clearly gives, at the first instance, decision-making to the local level, in the event of an appeal, the ultimate land use decision rests with the Ontario Municipal Board. Secondly, that as a result of maintaining the provincially led policy statement system within the Planning Act, that in my view, local councils and the municipal board cannot easily dismiss the provincial policy statements out of hand by using the have regard to rule. Same words, but in my view, a different context. We'll have to wait and see how they end up being interpreted. It'll certainly be an interesting, and I'm sure we'll all have some interesting arguments before the board. But I don't believe anymore that the board will be able to say, well, I've looked at the policy, I've had regard to it, I'm dismissing it. I don't think you can quite do it that easily anymore. And finally, my last conclusion would be that the provincial policies themselves have been tightened and made less detailed, complex, and confusing. In my view, the general thrust of the policy statements is to promote development in clearly defined circumstances. I thank everyone for their courteous attention.
Thanks very much, Steve. Now it's your turn. We'd like to open it up for questions or comments from any of the members of the faculty. And while you're thinking about those, if I can ask the members of the faculty, there's a fair number of chairs up front here, if you'd all please come up. And I know, given my past experience, I think we should reserve the two chairs front and center for Joanne and Nancy. They tend to be on the hot seat, and they know that when they come to these functions, so we might as well give them the available hot seats.
And also, just before I've been asked by Paul Trester to please, again, repeat, they would really appreciate if you filled out the program evaluation forms and left, there's a box out on the table. They would really appreciate having those before you left.
We've got our members of the faculty up here. Okay, out to you. Questions, comments, disagreements, areas that we can provide you with more information. Look at this array of talent up here. You've got to have some questions.
I was going to say, just a comment I was going to make on, it was 163, I believe, that introduced the provision to allow the board to dismiss on its own initiative.
Exactly. I just actually wanted to make a comment on that in response to Susan's discussion, and I wasn't involved in the drafting of those provisions, but one of the issues that may have been behind that, I know at the ministry you get dead files, and they really clog up the system. The proponent's no longer interested, the objectors disappeared, there's no statutory authority to close the file, and you've got a major paper and computer issue. I understand that provision was put there where the proponent no longer has an interest in the property and the objectors disappeared. The board was having a problem dealing with those files because they had no authority to close. So they had kind of a little closed file that wasn't really closed. I understand this provision was to give them the authority to make a motion to dismiss without a hearing, and if no one showed up, then they had a statutory ability to dismiss the appeal, and it was over if no one had an interest. So while there may be issues about how that power could be used or theoretically abused, I believe the issue behind it was a file management issue. And since I have the mic, I just may make two other quick comments. The person who said that if Municipal Affairs brought a motion, what would the board do, clearly hadn't read the Etobicoke cost decision. And just related to that, I would urge on Steve Diamond that any submissions that the bar may put forward in respect of the board clearly also deal with the issue of proper resourcing, because all of this is moot if the board doesn't have the tools to do the job, and I would just urge that as an addition to our submission once forthcoming.
On that point, is there any other members of the faculty that want to comment on Steve's comments with respect to tenure, term, board chair, resources? Anybody else want to comment?
I was just going to say, I mean, I think there's pretty unanimous opinion of the municipal section that Steve is bang on the points that he submitted. I think that will be our practice which comes forward from the section.
Bruce?
I just had a question and maybe a little follow-up comment. Someone had mentioned that they heard through the grapevine that there were 26 staff who had been given layoff notices at the board. Can you tell us, first of all, are there any of the caseworkers going by the layoffs? And if there are, what I'd like to say is in terms of board resources, I think those caseworkers have been very, very useful to the bar in terms of providing accountability in terms of the processing of applications and acting as intermediaries in terms of the status of those files. And I think every effort should be made to retain those caseworker positions because I think it's been a very sound investment resource.
Maybe I can just make one comment, and I wish the board were here actually to speak for itself. But I've looked at the business plans that all the ministries released, and my reading of those said that the board was given a dollar amount to reduce, as were all agencies, boards, commissions, and ministries, and they made the decision internally how to achieve that saving, and their choice was 13 staff and 5 member FTEs or people, and that it was 13 that were were cut, and that some of those were in fact caseworkers. And that really, I couldn't agree with you more, Bruce, and that's why my suggestion that our submission, while everyone may have views on the other issues, resourcing, the ability to do case management, the resources to get the hearings on are pivotal.
Steve?
Yeah. I was just going to say, the issue of resources is fundamental. I thought I mentioned as well, and I agree with your comment. And what I find interesting, again, about our systems is when the government went to cut the courts' budgets, Roy McMurtry stood up, felt he was independent enough to tell the government to get lost, and stood up for the judges and the people that are appearing before the court system, and knew he could do it without repercussion. I think the problem that we have today in terms of encouraging resources is that we're dealing with a tribunal that doesn't feel that independence, whose chair is up for renewal in September, October. And that's part of the problem. And I agree with you, Bruce, in response, that resources are critical, and Joanne, but if this board doesn't have that independence as well to take care of it or be able to make those comments, then the system isn't going to work for all of us.
My understanding was that I think 8 out of the 13 positions were caseworkers, and certainly the combination of plans administration branch not being there to scope official plan referrals, the straight appeals to the board, and then losing 8 caseworkers who people were calling upon to think of, somebody's got to do that scoping, or if the whole thing just ends up in front of a pre-hearing conference, it's a complete mess, and it's going to be very costly for those that are involved. So there are a number of ways that this matter should be addressed. Hope for more comments and questions.
I'm on a roll here.
Sure, go ahead. Floor is yours.
Just on another point, in terms of the prescribing of the information, which triggers the time frames under the Planning Act, one of the things that occurred to me during the presentation was that it seemed to me, in terms of the provincial ministries and their circulation for comments from municipalities, that there's an apparent effort here to download some costs from the province onto the municipality in terms of the municipality undertaking these technical reviews. We do work for the city of Etobicoke, so typically if a development application came in and there was some environmental issue, we would circulate for comment to the Ministry of the Environment. We'd wait for 6 months to get the comment back, but we would rely on their expertise in terms of trying to deal with the application. Now, as I understand it from the submission, one of the objectives here is to have the municipality deal with these technical reports on its own. And presumably there are a variety of ways that they may try to respond to that, many of which from the suggestions seem to involve situations where the municipality puts a cost on the developer to go out and either have peer review funded or else perhaps have an independent consultant to do the work. In terms of the prescribing of the information, which is the trigger for the time frame, would it be open to the municipality to say, we're going to have a bylaw, and under the bylaw, you're going to have to carry the cost of having certain types of reports prepared, and those reports will have to be filed as part of this prescribed information for your time frame to start to run. Because I can certainly see a situation where the municipality can say, well, we can't do an environmental report, we don't have the expertise, and we want you to carry the cost of it. And the developer will say, we're not going to carry the cost because we're satisfied there are no environmental issues. And I'm not sure what leverage the municipality would have in that kind of situation to force the report. Would anyone comment on that? Long question. Joanne, do you want to go?
Maybe I'll start. I think it's fair to say that the statute, as it's currently drafted, doesn't allow the municipality to do that. I think there was some ambiguity under 163 about what exactly did start the time frame running, and I think this bill is clear that additional information, the failure to provide it, doesn't stop the clock from running. In terms of leverage, I think that would be an interesting topic to discuss. Obviously, there is a timing issue in that the municipality has control of that file, and if no processing is done because the technical information you seek isn't there, that could have an effect. But other than that, I don't see a lot of statutory mechanisms.
So in terms of these other examples of different approaches having been worked out, some of which would involve the developer picking up the cost for a peer review or perhaps funding an independent study, is this just being done through negotiation and hard bargaining, or is there some sort of punch the municipality would apply to force the developer to cop the funds?
Well, I think up until 1994, there were no really requirements in terms of anything that had to be submitted with an application for a planning approval under the Planning Act. I mean, I think that the law, when I researched it, was pretty clear that as long as you said who you were and what you wanted, that legally constituted an application that could, in fact, be referred to the board. But I think that municipalities, there's been developed a practice over time that they have application forms and they have requirements, and people play by those rules because they like to think that they aren't just carving a path to a municipal board, but they're engaging in a planning process where it is a possible result that they will get what they want or a variation thereof. And I think the planning system has been built on that. I think 163 tried to codify that and put into prescribed information, even the contents of an official plan, what I would call a subjective component, which had really more than factual information, but things like reports, etc., that would be required. And that met, as I'm sure you're all aware, with a lot of controversy and certainly a lot of disagreement from the development industry. And that didn't find its way into Bill 20. And in fact, if you look at the regs on prescribed information, it is still, while it's much broader than what existed under the 83 Act, it's still fairly simple in its scope. I see Mary Flynn has a comment, but that's what we've got.
I think actually what Bruce was getting at was slightly different than that. What he's saying is that the municipality is saying we want certain reports, provide the reports to them, and you paid them for your $50,000 for very comprehensive disaster servicing plan that has an environmental component. And they come back to you and they say, okay, now that you've spent $50,000 on that thing, we now have to hire our own experts to review that plan. So we want $50,000 to be paid for us to go and get another expert to review the plan. And I think what Bruce is saying is, isn't there at some point in the simply say, the requirement was to give you that report, gave it to you. If you want to review it, you have to split the bill. I guess Bruce, working for the side of the municipality, is saying, how do I reduce that money? Can I force them to dictate to the municipality to do a peer review or do their own total reports? It's getting very expensive. I mean, it's got enough application reports to say, municipalities, even where they participate in joint consultancy industry, they participate in the terms of reference that your report is going to involve. They then turn around and say, well, we want $50,000, we're going to go out and hire our own consultants. Totally review your report. I mean, at what point can you say to them, enough is enough, I'm not going to keep my own.
So, and Bruce did start out his question on the municipal plan review issue, and maybe I could just respond to that. The philosophy behind this is that site-specific or local planning is a local matter, and it's not a provincial matter. Provincial role in the planning system is to develop policy. So the bottom line is municipalities and their constituents, including developers, have to agree on a process that is agreeable. The municipality is a decision maker. They have to make a decision, and they have to be confident that they're making a decision that's reasonable and what they need to make that decision. The process by which that's done, the developer pays for a lot of it, and yes, the issue certainly comes up, how much is too much and what's reasonable. The role of the province, which is half of your question, why shouldn't they be doing it? Well, they, like everyone else, have financial problems, and they have chosen to not do site-specific planning, and the whole philosophy of the Planning Act is to move them out of that arena. It's now at the local level, and the Act doesn't provide, I would agree with you, any guidance on how to do that, except that there is provision for an application fee, and the law will tell you the application fee should cover the reasonable costs associated with the processing of that application. And that is, I think, where the issue and debate, and perhaps even friction between developers and municipalities will lie. And how they resolve that in each specific area, I don't know.
I suggest, too, I think the fees may be one place where it's really going to come to a head, and that urban municipalities are going to start to behave like a lot of rural municipalities have had to for the last decade, and are looked to see a very direct relationship between the fee paid and the actual cost to the municipality to process the application. And it would appear that the provisions of Bill 20 certainly provide for that. Or if you compare that to the licensing fees, the Bill 20 provisions seem to suggest there's got to be a direct relationship between the actual cost and the fee for the application. Licensing seems to suggest that you can also have a revenue opportunity in addition to that. Other questions or comments? Yes, John.
Question probably for Joanne. The Act speaks of this entity called the Municipal Planning Authority, which sounds very much like an old joint planning board in many respects. And you mentioned in your presentation that consideration is being given to how those are going to be implemented. Could you tell us more at this point as to the approach the province is taking to establishing these, whether any criteria they're going to use, or exactly how this new tool is going to be used?
There's certainly, as you know, no statutory provision or regulation that would shed any light on that. I think the minister, when he's been out across the province, has said that there is a need to balance the incentive to do planning at the county level with the reality that there are development pressures in certain parts of the province that aren't being addressed through a county planning system, that any group of municipalities that come forward to him with a proposal will be looked at and seriously considered. And I believe that the way, because this is, while it was contained in 163, really this is the first time we've actually dealt with any, what used to be called, I probably should have put this in my presentation, there's no such thing as a plans administration branch anymore. That changed, and I'm probably going to get this wrong, but I believe it's called the Provincial Planning Services Branch, and it's just one. There's no division between North and East and Central and Southwest anymore. But those people will sit down with that municipality or group of municipalities and discuss it, and they are, through the process, developing some informal criteria, and I think they hope to actually have some of those, but they felt it was artificial to develop those prior to knowing what the issues in the process is. And I think what I could do is undertake to find out whether there anything further has happened on that, because I really haven't been involved recently.
Yes, sir.
Bill 26 seems to contemplate a number of regulations published. Does anyone know or have to see those?
Most of the regulations that I can recall being required under Bill 26 have now been filed. With respect to a lot of them, this was fairly recent, like probably last week. But I think if you look now, you'll find them in the Gazette.
The main regs were the restructuring regs that were lacking, and those restructuring regs were filed on June 1st, I think.
So they would be available to the government bookstore?
They're in the Gazette.
They're in the Gazette.
Yeah. Questions or comments? Otherwise, it looks like it's a hungry audience, so let's draw to a close. Thank you very much, and thank you to our faculty.